Friends, in session number 28 of the series on military law, we shall see the confirmation and promulgation process relating to a court-martial. Now, confirmation and promulgation are only applicable in three types of court-martial, that is general court-martial, summary general court-martial, and district court-martial. It does not pertain to summary court-martial. The term confirmation in military law, it refers to confirmation of finding and sentence. It is carried out by the officer or an authority which is called confirming authority or confirming officer. So till Chief of Army Staff, it will be called confirming officer, and if the power is vested in the central government, then it will be called confirming authority. And the relevant statutory law provisions are in section 153. They state that no finding or sentence of a GCM, DCM or summary general court-martial shall be valid except so far as it may be confirmed as provided under the Act. So the Act provides where confirmation is needed and who would do it. If provisions of section 154, 155 and 157 are referred, it says that authority to confirm the proceedings of a GCM vests in the central government or any officer empowered by the central government by way of a warrant. So the warrant is issued. Now these warrants are not issued by name, they are issued by post. For example, General Officer Commanding 9 Infantry Division or General Officer Commanding 11 Corps. So the incumbents may change, that doesn't matter as long as he is occupying that chair, he is vested in the authority by virtue of the warrant that is issued. Coming to district court-martial, it is section 155 which states that any officer having power to convene a GCM or by any officer empowered by the warrant of such officer. That means that a convening authority of a general court-martial or somebody who has been authorized, empowered in this case, by the convening authority can confirm the proceedings of a district court-martial. Lastly, summary general court-martial, section 157 Army Act says that the proceedings can be confirmed by the convening authority itself, or if he so directs, by any authority superior to him. So these are the provisions with regard to confirmation of finding and sentence. Now, confirming authority, when has a warrant, as a holder of a warrant, may have certain limitations put on the exercise of this authority. And section 156 states that a warrant issued under the provisions of section 154 or 155 may contain such restrictions, reservations or conditions as the issuing authority may fit. Now these restrictions may say that you will confirm the proceedings except for officers up to the rank of brigadier, or except for offences relating to section 34. Now in this way restrictions or reservations or conditions may be placed. Now confirming authority has also been given authority to mitigate, remit or commute the punishment. Now firstly, it is to be noted that this authority is in relation to finding, but the finding cannot be changed. It is only the punishment which can be changed by way of mitigation, remission or commutation. Now the exact purpose and the meaning of these words we will see in the next slides. Commutation is changing the description of punishment by awarding a punishment lower in the scale of punishment. Just to illustrate, somebody who has been sentenced to be cashiered by a general court martial, commutation may change cashiering to dismissal or to severe reprimand. So it is a punishment which is lower in the scale of punishment that is given. That's called commutation. Mitigation is awarding a less amount of same species of punishment to which an offender has been sentenced. For example, if an offender has been sentenced to undergo 18 months imprisonment, so it can be mitigated to, instead of 18 months, to 12 months or 9 months, like that. And remission is doing away with the whole or part of the sentence. So either the entire sentence or part of a sentence may be remitted. To illustrate, 18 months may be made into 12 months, or 18 months may be mitigated. So these are the three authorities, powers provided to a confirming authority with regard to punishments. Now, the Army Act Section 160 provisions in this regard are there on the slide in front of you. And these 4 bullets are quite significant, which state that any finding or a sentence of a court martial which requires confirmation may be once revised by the order of the confirming authority. 3 points to be noted are: firstly, only that court martial which requires confirmation. This is there because summary court martial does not require confirmation. Therefore, finding, revision of finding or sentence is not applicable in the case of a summary court martial. Secondly, it can be revised only once. This process cannot be done beyond once. And thirdly, it can only be ordered, can be so done on the orders of the confirming authority. Now, second bullet says that on such revision, if so directed, additional evidence may be taken. If there is a revision of finding and the confirming authority feels that there is a need to revise the finding and take additional evidence, then additional evidence may be taken. And evidence with regard to what would be taken is contained or will be so indicated in the revision order which is issued under the signatures of confirming authority. Next point is that on revision, the members of the court shall be same as they were there earlier, and if an officer is unavoidably absent, the court martial shall still continue, provided it has still 5 officers, and SGCM or DCM it has 3 officers, because the number of officers cannot go below what is prescribed. Now, revision order, as it was told to you, it is the order issued by confirming authority or the officer who is ordering revision to so spell it out and also indicate the reasons for so doing. So this order is in the sense of, or is in the shape of a speaking order, and it gives out reasons why a revision has become necessary with regard to that court martial on that charge. Army Rule 68(2) makes it clear that fresh evidence shall only be taken when the court is so directed. So the implication is that court on its own may not decide to go in for fresh evidence. If there is a need for this, it will be so indicated in the revision order. However, if the testimony of a defense witness at the revision so requires, the court may permit prosecution to call or recall any witness for purpose of rebutting any material statement for the defense. Let me explain this. Assuming that in a court martial, a defense witness has brought out an aspect of the evidence which recalls for comments from the prosecution. In that situation, prosecution would request the court that it be permitted to call or recall any witness with regard to that specific aspect, and the court may so permit. The other point is with a statement, a sentence is alone sent back for revision, not a statement. Sentence is alone sent back for revision. Court shall not revise the finding. In that case, it will only revise the sentence. If the finding had been sent back for revision, and in the event that the court does not adhere to its former finding and records a fresh finding which involves the sentence, then obviously the court will thereafter, after recording the new or revised finding, will decide on a fresh sentence. So this is in Army Rule 68(5). Review of court-martial proceedings. The procedure lays down the judge advocate at the trial will send the proceedings to the deputy JAG or AJAG at the command for post-trial scrutiny, and then the comments issued at the headquarters command by the office of deputy JAG are called report on trial. Earlier, before the assembly of the court martial, it is called report on application for trial, and at this stage it is RT, report on trial, and this goes from the JAG officer, deputy JAG or AJAG to the confirming officer. And similarly, proceedings of DCM are also required to be sent, and for taking the advice of Deputy JAG or AJAG command if the sentence is dismissal or above. However, if it is less than deputy dismissal, then such advice may not be needed. Now, confirming officer under Army Rule 70 has 4 options. He can confirm, he can refuse confirmation, which amounts to not confirm. In that case, proceedings till they are confirmed, they are not complete, the proceedings will remain incomplete. It can reserve confirmation. A div commander may say that I reserve confirmation to be done by my higher corps commander or RB commander. Or fourth option is that it can confirm the finding and sentence but vary, commute or remit this sentence. Earlier you had seen that finding cannot be tinkered with by the confirming authority. It can only vary, remit or commute the sentence part of it. Now this slide in front of you has certain specimen minutes of confirmation. For example, he can say confirming authority confirmed, or can say I direct that the sentence of rigorous or simple imprisonment shall be carried out by confinement in military custody or in civil prison, and accused is recommended what division, because there are divisions in the prison A, B or C, order to that effect. Or the confirming officer can say I vary the sentence so that it shall be as follows, and confirm the finding and sentence as so varied. Or there can be an order for mitigate, remit or commute. Like that, these specimens are available in the Manual of Military Law, and it is important that the exact wordings are carried so that the court-martial proceedings are put to effect and into execution exactly as regards the orders of the confirming authority. So, it is written there, one of the confirmation minute, I have dealt with the finding or findings and sentence in the manner stated in the last column of the said schedule, and subject to what I have stated, I hereby confirm the finding, sentence. So these are the different manners in which the proceedings are provided a confirmation minute which is signed by the confirming authority. And then you would find that on this slide in the end is the promulgation minute, where the officer who's in charge of the document, he has the promulgation carried out and says promulgated and extracts taken for the purpose of records. Sorry. The process of promulgation, what it means is to read out to the accused the finding, charge, actually it is charge, finding, sentence, or any recommendation to mercy, confirmation or non-confirmation of the proceedings, so that the accused knows what has been the fate of the court-martial. He has a right to submit a petition that is explained to him, and it is written in the court-martial proceedings. Sorry. The effect and significance of promulgation. It is to be appreciated that till the promulgation has been effected, confirmation is not complete, and finding and sentence shall be held to have been confirmed only once they have been promulgated, and this is borne out from section 153 of the Army Act and Army Rule 71. In conclusion, it is to be appreciated that confirmation and revision process are meant to enable the court-martial to rectify any error, infirmity, or informality in the proceedings. If there is any error which has crept up, then an option or a remedy by way of revision is provided for, and promulgation formally informs the accused about completion of the court-martial process in respect of him. Thank you.